Hey, estate planning attorney Paul Rabalais here, and in this video we're going to talk about what you can do now to prevent your will from being contested later. Okay, so what's spawned this video is the fact that some people over the years have come into my office and have said, you know, Paul, I want to get my legal affairs in order. I know how I want to leave my estate when I pass away. And sure as shooting, Paul, I can tell you right now that this one person is going to contest my will. And maybe they think that because they've told somebody that. Or maybe they already contested another estate that they were either involved in or thought that they should have been involved in. But something, you know, we hear something, you know, like that from time to time. Or maybe, you know, a parent might come in and say, you know, I want to leave this to my daughter, but I know my son-in-law is not going to like it, so he's very litigious and likes to argue, and he's going to contest, whatever the reasons might be. Some people tell us they know in advance, and other people don't know it in advance, but they know enough to know that sometimes, you know, sharing an inheritance brings out the worst in people. So this is all about what, I almost dropped my little clicker here. This is all about what you can do now to prevent a will contest later, because I will tell you there is a dramatic difference between the uncontested estate settlement and the contested estate settlement. Dramatic difference. So here's some things you can do to prevent your will from being contested. Number one, and there's 7 items here. Number one is make sure or ensure that the validity requirements of your will is met. So for example, and states can vary here and do vary from state to state, but I'm an estate planning attorney in Louisiana. So here in Louisiana, we permit really 2 kinds of wills. One's called the holographic testament. It's when it's completely in the handwriting of the testator. It's written, dated, and signed all in the handwriting of the testator. And so those are the basic validity requirements for an holographic testament. But most wills in Louisiana are what's called a notarial testament, and there's more formality requirements. They are typically typed up. They have the language in the will that makes it a valid notarial testament. We call that an attestation clause. It's signed by the person whose will it is. It's signed in all of the right places. There's the required notary and 2 witnesses that are present. You know, the witnesses are not heirs. And so not only do the notary and the witnesses sign in the appropriate places, but they're also present, you know, as part of that formal signing experience. So that you want to make sure you meet all of those validity requirements. Number 2, you want to make it easy to prove your competency or capacity if that gets questioned later. You know, some wills are questioned because, you know, Aunt Nelda, she didn't know what she was doing when she signed her will. You know, she was starting to have some dementia, Alzheimer's, whatever. So you want to make it easy to prove your capacity or competency. And many people, you know, in the movies, and quite frankly, it used to be that you have to have this requirement, you know, I, Nelda, of sound mind and body. That's no longer the requirement for capacity, at least in my state of Louisiana. The requirement is that you be able to comprehend generally the nature and consequences of the disposition that you're making. So that's what has to be shown later on, you know, when your will is being probated through the court system. So what can you do to avoid to help prove your competency or capacity? You know, if you feel like it's going to be questioned, maybe you should see your doctor at the same time that you're making your will. And that way the doctor can make their notes, make their report, so that can be shown later that at least in the medical examiner's eyes, that you have the appropriate capacity to generally understand the nature and consequences of the disposition that you're making. Also, if you think it's going to be questioned, you know, have a conversation at the time that you're writing your will. You know, have conversations about what you're doing with the notary and the 2 witnesses, and perhaps even have them document, you know, their view of your, you know, capacity to understand things. So all that can make it easy to prove later that you had the appropriate capacity at the time you did your will. Number 3, remove the appearance of undue influence. We see this as a problem from time to time. So sometimes there's one family member or friend, and this is just an example. Sometimes there's one family member or friend who is the primary caregiver of the person who's writing the will, and oftentimes naturally the person who's writing the will just wants to leave more or all of their estate to that primary caregiver, whether it's a family member or a friend. And so really, when you're going through the estate planning process, you need to take all of those actions independent of that caregiver who will be the significant or sole heir when you pass away. So you want to do the scheduling of the conversation or call or Zoom call or face-to-face meeting with that professional who's going to help you get that will prepared, that attorney perhaps. You're going to want to get yourself to the office. You're going to want to have that conversation, alone with the attorney, and don't bring that heir into the office with you. Don't bring that heir into the meeting with you, because that's going to look bad down the road. So make sure you take all of those estate planning actions independent of that sole heir. So when it looks bad, it's like that primary caregiver, and I know it's tough to do because they are your primary caregiver, but it just looks bad when that primary caregiver calls the lawyer, makes the appointment on your behalf, drives you to the attorney's office, walks you into the attorney's office, goes into the attorney's office or conference room with you. Sometimes that primary caregiver even likes to try to control the conversation and lead the person who's writing the will into what they should be saying, and all that just looks bad. You want to make sure you avoid that. Number 4, make sure the language in your will is clear. And we see this as a problem sometimes when you're in perhaps one of those 25 or 26 states where those states do permit people to handwrite their own wills without the services of a professional or a lawyer. Or sometimes you see this as a problem when the language isn't clear, when perhaps an inexperienced attorney is drafting the will. Just to think of a possibility, sometimes things can be written that are subject to different interpretations. One example might be Sally writes her will and she says, "I leave my money to Mary." So what does that mean? Does that mean Sally leaves the cash money that she has in a shoebox to Mary? Does that mean she leaves her checking account to Mary? Does that mean she leaves her savings account to Mary? If she has some CDs, does that go to Mary under this, "I leave my money to Mary"? What about the stocks and the bonds and the mutual funds and the money market accounts? Does that fall under that definition of money that Sally's leaving to Mary? So all those, you don't want to have situations where there are things that are subject to different interpretations, because that's a clear signal that there's going to be a will contest in the future. Number 6, communicate the why. So sometimes a parent may have 3 children, and a parent's estate planning legal documents say, "I leave 40% to child A, 40% to child B, and 20% to child C." And so, and that's all they did. And so the person dies, sees like, what is the deal? I don't think that's fair. I'm going to try to contest this will, either because I might be able to be successful in an argument that a validity requirement is kind of questionable, or child C might say, Mom was influenced by child A, so, the will should be invalid. Now, if Mom, who not only wrote that in her will, also had some kind of side letter, maybe even in her own handwriting, that wasn't part of the formal will, that said, might say something like, "In my will, I left 40% to each of child A and child B and 20% to child C. And the reason I did that was because during my lifetime, I helped out child C a whole lot more than I did child A or child B. So I only thought it was fair that I leave child A and child B more than child C, because I paid for child C's education and her house and her car, and so blah, 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 blah." So that can sometimes help eliminate or avoid a will contest when you somehow communicate the why. And then number 7 is make sure the right people have access to your original signed will when you pass away. Because if the original will is not produced, it can create a presumption that you destroyed the will with the intent to revoke it. So in my previous example, if you left your original will with child C, I'm not questioning child C's what their thought process is, but when you die, child C might conveniently kind of tear up that will if child C was the one who was in possession of the will, and then there's no will, child C gets a third, so child C gets more. You may want to leave your original will with one or more of the people who have an incentive to see that your will actually gets produced, gets probated, and your estate, falls subject to the will that you did prepare. Okay, so those things, if you could just do those things right there, you'll be really increasing the likelihood that there'll be some kind of will contest when you pass away. Will contests and estate litigation is so bad. I've been doing this for 30 years, and I guess I was about 5 years into it where I said, no more. I'm not going to be involved in any more of these estate contests where so-and-so is arguing that after mama died, sister went into the house, took, 6 plates and 4 saucers, and now they're going to argue about it. So this is really, kind of ingrained in me, is preparing things ahead of time to avoid those problems later. So if that is of interest to do, you'll want to make sure you click the like button. And if you haven't already, click the subscribe button and the notification bell so you don't miss anything, and you get to see all my estate planning educational and informative videos that I make almost on a daily basis or whenever I get around to it. Y'all have a great day. We'll see you next time.